in the Circuit Court of Wright County, Missouri. State of Missouri. Plaintiff. Case number 22 WRCR 00553 Darrell Leon McClanahan 3. Defendant. N. The above styled cause has been set for trial in Division 1 of the Circuit Court of Wright County. The defendant is charged with the crimes of harassment in the first degree for events which occurred on or about January 12, 2021. The state of Missouri requests this court to enter its order prohibiting defendant or his counsel from making statements in the presence of the jury, or adducing any testimony or evidence, concerning the following. Exculpatory statements by defendant 1. Any exculpatory statements made by the defendant to any witnesses should be excluded, as such testimony would be self-serving and hearsay. Such statements including self-serving denials to witnesses, family members, and his attorneys. In support, the state cites the D. 1994, holding that defendant is not entitled to introduce his self-serving declaration that is independent of theirs. D. 1993, holding that defendant is not permitted to create evidence by adducing testimony of his own self-serving declaration, and State v. Beck, 673 SW2D 122, Mo. App. E. D. 1984, holding that trial court correctly sustained objection of defendant's out-of-court statements that were favorable or consistent with defendant's position at trial, as they were not admissions and were thus self-serving. Failure by state to call endorsed witnesses to failure of the state to call all of its endorsed witnesses for trial. E. D. 1981, state's decision not to call certain witnesses constitutes trial strategy and is irrelevant and immaterial to any fact in issue. Burden of proof criminal versus civil 3. Explain to the jury the difference in the burden of proof in a criminal case as compared to the standard applicable in a civil case. This is a matter for instruction by the court, not questions by counsel during voir dire. State v. Hines, 500. Defendant's character in first name. 4. To preclude any references to the defendant's specific, good, relationship with his other family members, jailers or friends in the guilt phase of the trial. Character evidence is limited to the defendant's reputation in the community and cannot be shown by specific, good, or bad acts. State v. Burke, 809 SW2D 391, Mo. App. E. D. 1990. To preclude any character or reputation evidence pertaining to the defendant not relating to the time of, or a reasonable time prior to, the date of the alleged offense. Reputation evidence must relate to the time the crime was committed or to a reasonable time prior thereto. State v. Adverse inference tests. 5. Any question or comment that physical evidence found and seized at the scene or on the defendant or another was not tested by the Missouri Highway Patrol Lab using DNA analysis, or that the law enforcement authorities did not perform certain tests at the crime scene or collect certain evidence and have it tested for blood, fingerprints or other analysis. No adverse inference can be drawn from the fact that such evidence is not adduced by the state, and the state does not need to account for such evidence not being offered at trial. Such a decision to not offer or allude to such evidence constitutes work product in that it is part of the state's trial strategy, nor may the defendant have or argue an adverse inference from the fact that the state declined to perform tests. In support, the state cites State v. Goforth, 736 SW2D 552, 554, Mo. App. E. D. 1987, holding that it is not incumbent upon the state to perform particular ballistic tests and that this same rule applied to other types of tests the state could possibly do. See also State v. Simpson, 611. E. D. 1981, holding that the state is not bound to gather and present all physical evidence conceivably germane to its case in chief, and that the state is not required to account for its failure to gather or present such evidence. State v. Holmes, 389 SW2D 30, 34, Mo. 1965, holding the defendant may not draw an adverse inference from the fact that the state declined to test for fingerprints. Argument or testimony that someone else other than defendant committed the crime. 6. Evidence that another person had an opportunity or motive. Way to commit the crime in question has consistently been held by Missouri courts to be inadmissible without proof that the person committed some act directly connecting him with the crime. The Missouri Supreme Court stated that the test for the admission of such evidence is that it must be such proof as directly connects the other person with the corpus delicti, and tends clearly to point out someone besides accused as the guilty person. Disconnected and remote acts outside the crime itself cannot be separately proved for such purpose, and evidence which can have no other effect than to cast a bare suspicion on another, or to raise a conjectural inference as to the commission of the crime by another, is not admissible. Humphreys, p. 288. See also E. D. 1984. Consequently, the prejudicial effect of such evidence would far outweigh any probative value this evidence might have. Bad acts of state witnesses. 7. The state believes that counsel for defendant will attempt to refer to illicit testimony regarding, or argue specific acts of immorality on the part of the state's witnesses in an attempt to impeach the state's witness. Section 491.050, RS-MO limits impeachment to prior convictions and prior findings of guilt. See MyCR 3D 310.014. Also in Missouri, the credibility of a witness may not be impeached by evidence that a witness's general moral character is bad. State v. Miller, 680 SW2D, 2. The specific acts of immorality do not address the witness' poor general reputation for truth or veracity. State v. Trimble, 638 SW2D 726 Mo. Bank 1982, nor are they probative of the truthfulness or veracity of the witness. State v. Stith, 660 SW2D 419 Mo. A. The number of arrests, municipal convictions, or specific allegation of immorality of the state's witnesses which did not lead to convictions as said testimony is inadmissible and improper cross-examination. State v. Wise, 879 SW2D 494, 510 Mo. Bank 1994, State v. Shupp, 6. Absence of fingerprints 8. To preclude the defense from introducing or arguing the absence of fingerprint evidence. There is no duty to take fingerprints, and their absence is not relevant. See State v. Boyd 688 SW2D 791, WD 85, State v. Bank 87, holding that cross-examination of police officers as to why they did not collect hair, fiber, soil, or gunshot residue from defendant or crime scene is not proper, as defendant may not show adverse inference from failure of police to gather evidence. Bank 87, holding that cross-examination of police officers as to why they did not collect hair, fiber, soil, or gunshot residue from defendant or crime scene is not proper, as defendant may not show adverse inference from failure of police to gather evidence. Opinions of non-expert witnesses 10. To preclude the defense from introducing or eliciting personal opinions as to the guilt or innocence of the defendant. It is improper for a witness to render an opinion as to the guilt or innocence of the defendant. State v. Nor is it proper for a witness to testify to a conclusion when it has the effect of answering the ultimate issue the jury is to decide. State v. Carson, 596 SW. Wherefore, the state prays this honorable court order counsel for the defendant not to elicit testimony regarding the above stated matters or to make the above stated arguments at the trial without first approaching the bench and asking said questions outside the hearing of the jury. Respectfully submitted. L.H.R. Matthew Weatherman, number 65625, Prosecuting Attorney. P.O. Box 245. Ava, Mo 65608. P.H. 417-683-2919. Fax 417-683-0138. N.V.